The presentation is going to start in 1 minute. Presentation is going to start in 30 seconds. Okay. Hi, everyone. My name is Alejandro Luna, partner at Olivares. I am mainly devoted to IP litigation and life sciences. Welcome to our third panel today, now related to the patent law in Mexico, under the scope of the new IP law. It took more than 25 years for the expected new federal law for protection of industrial property. As NAFTA did in the past, the negotiations and modernization of international treaties such as CPTPP, USMCA, and the treaty with the European Union stimulated the legislative activity in the field of industrial property. Two senators from different political parties presented the main initiatives for the new law on the matter. The corresponding discussions with the Mexican Congress ended in the federal law for protection of industrial property. In general terms, the new law will have positive effects. Certain faults may be corrected and perfected through the also expected regulation. Partners and associates of our firm, through the corresponding legal channels, we participated in the legislative process. Now, in order to celebrate the entry into force of the new law, just 5 days ago, on November the 5th, Olivares is pleased to present with colleagues, friends, and clients this event of 3 panels named Ask Olivares about the new IP law. It is a pleasure for me to moderate this part of the Olivares efforts related to the patent law, along with 3 representatives of our patent department, my partner Daniel Sanchez, and associates Mauricio Samano and Manuel Mateos. The name of this collection of panels that we have today is Ask Olivares. Therefore, the format will be that my colleagues will start with a brief presentation highlighting the main differences or changes in the new IP law. Immediately after, we will start responding to your questions. So this is the opportunity for consulting about the new patent law in Mexico free of charge. Thus, do not hesitate to use the Q&A's chart in the template of the platform. So without further introduction, I will pass the voice to the experts in the patent field. And again, we will be more than glad to hear your questions. So Daniel, Mauricio, Manuel, please start.
Thank you, Alejandro. Before getting into the details of what this new law is providing us since last week and from the to the future, we would like to comment about this new digital electronic environment in which we are now involved. In many patent offices around the world, the possibility of filing patents in an electronic manner or digital manner was available for a long time ago. It was available also for us, but the system that the patent office implemented was having some problems, and that's why we will not encourage our clients to use it. However, due to the pandemic, the patent office put most of his resources to improve the digital systems. And right now, the possibility of filing electronic applications is a reality. The system is working well. We're using it every day. And there is also a possibility to convert whatever was filed in paper physically to a digital environment through a petition. This was implemented during the pandemic, and it is working right now and is working good. And actually, the patent office is during this week and the next 2 ones making a discount over the government fees to encourage practitioners to convert physical files to digital files. So that's important to have in mind because, I mean, yesterday we have a very good news from Pfizer, but we don't know yet how this pandemic is going to develop or to evolve in Mexico, and if a new closure of the patent office takes place in the future, the users that has converted all the physical files to electronic will be able to continue the prosecution, and it won't be the case the other way around. So that's important to have in mind. But getting into the new law, what is most important, and Manuel, if you can change the first thing that we need to have in mind is that although the new law is already in force and it has a new set of rules for many different items, the former law will be still applicable for any application that was filed before November 5th. In some cases, these are good news, especially for divisional applications, as Mauricio is going to explain us later on. But in other cases, the applicants will not benefit from these new provisions. So it is important to have in mind when the application was filed to see which rules apply and which law is going to be applied. And it is important also to disregard the granting date because it won't be relevant to determine which applicable law, which will be the applicable law. So with that in mind, I think that we can go and jump into the new provisions that the law has. So Manuel, if you want to continue.
Thank you, Daniel. Well, there are some changes, relevant changes from a patent prosecution point of view. One of them is the modifications in the regulations of priority rights. And consistent with the former IP law, the new IP law provides as a general rule that in order for the recognition of the priority rights, a certified copy of the priority document must be filed with the patent office within 3 months after the filing date of the application. This is an obligation coming from the law, and the patent office does not issue any official communication requesting the filing of the certified copies. If the certified copies are not filed within such term, the priority rights are not recognized. Now, the new IP law provides that the head of the patent office will issue a decree indicating the circumstances under which it will not be necessary to file the certified copies. And this is a very positive change because sometimes we face difficulties with our clients to get the certified copies of time. So until that decree is issued, it will be necessary to file the certified copies, but we expect the decree to be issued soon. In fact, in August, the Mexican Patent Office notified WIPO, informing WIPO that they would start using the digital access service to verify and deposit priority documents. So, as of November 3rd, the Patent Office will act as depositing office of certified copies of patent, utility models, and industrial designs. And it will also be able to access the WIPO database, the DAS database, to verify the certified copies. So even though there's not a formal decree yet, the Patent Office is already acting. Finally, on priority rights, there's a new cause of invalidation according to which a patent will be invalid if the priority was mistakenly recognized, and such recognition is relevant to the substantive examination, meaning novelty and inventive step. Another relevant aspect of the new law are all the provisions regarding the inventor's assignment and labor relationships. Even though these were recognized in the former laws, in the former IP law, it is more clearly worded and explained in the new law. Now, as a matter of principle, the right to apply for the patent belongs to the inventor, and the inventor may assign to a third party the rights to the invention. This can be done, as set forth in the law. There are two examples of how this can be. Is through an assignment agreement, which must be signed by both parties and indicate the subject matter of the agreement, which is usually the title of the patent. But it can also be assigned to an employment relationship. The assignments agreements are governed by our civil law, but our civil law also recognizes any agreement executed abroad. And employment relationships are governed by our federal labor law. According to our federal labor law, if the employee works in developing or improvement or technical aspects of the company, the invention will belong to the employer. Otherwise, in any other case, the invention will belong to the employee, but the employer would have a preferential right for the acquisition of the invention in equal circumstances. Another relevant aspect is that now our law specifically provides that the employment agreements executed abroad will be recognized for the assignment of the patent, and it will be recorded as such. And this means that it will only be necessary to meet the requirements set forth in the foreign law, which simplifies the recording of these kind of agreements. Finally, another relevant aspect is that, consistent with all the new technological era of the Mexican Patent Office, it will now be possible to file e-signed documents before the Patent Office to prove the assignment of rights or the employment relations. So I am going to pass the voice to Mauricio Samano to explain a little bit about grace period and prior disclosure.
Thank you very much, Manuel. Well, regarding grace periods, this was also available in our previous law. We had a 1-year grace period before the filing date of the application or the recognized priority date, if that was the case. But that grace period was limited to publications, to disclosures that were made by the applicant or the assignee. Now, with this new IP law, the possibilities of disclosures for applying today to this grace period has broadened. Now, all disclosures made either directly or indirectly by the applicant will qualify. Also, any disclosures made by third parties that obtained the information directly or indirectly by the applicant or his assignee will apply. And also any publications of patent applications made by a foreign patent office due to an error, or a publication of a patent application made by a foreign office, which was filed by a third party, which obtained the information from the applicant or the assignee, directly or indirectly, will also qualify for this grace period. So in a nutshell, I would say that this is in line with what was previewed by the USMCA treaty and is indeed a positive change in our law. The next slide, please. Oh, great. So new uses. Now, new uses were already protected in the practice in our previous law. Well, in the practice, I'm sorry, but they were not specifically contemplated as patentable subject matter in our previous law. Now, this new law that we have specifically recognizes that new uses of known compounds are considered patentable subject matter in our country. So all the claims that we used to include with the previous law, EPC 2000 claims, the concept of compound X for use in treating disease Y, and the use of compound X for the manufacture of a medicament for the treatment of a disease Y are now specifically supported in our new law. So that is a great news. Now, double patenting. That's also something that was available in the practice, but not specifically recognized in our previous law. So we had several double patenting objections, both in pharmaceutical or biotechnology areas and also in the mechanical electrical areas, in which the examiners raised double patenting objections when there was overlap in the scope of protection between the divisional and the parent case. Now, this double patenting provision has been specifically included in the new law, and at least what I feel is a little worrisome, which we hope will be clarified in the regulations that will be upcoming, that should be published soon by the Mexican Patent Office, is that a patent will not be granted to an invention that is identical to another one or that does not have substantial variations in the technical characteristics of the invention. So this substantial variation language leaves doubt on exactly in which case scenario we would be in a situation that a double patenting objection would be triggered. Would it be enough to have a minor scope overlap to trigger a double patenting objection? We're not sure at the moment. So we are attentive to see what the regulations of the new law will say about that, so that we can advise our clients accordingly. The next slide, please. Now, about divisional applications. In my point of view, this is the most worrisome of the situations that we have regarding patent prosecution in our new law. The current practice is that divisionals can be filed either voluntarily or by the issuance of a restriction requirement by the examiner. So in the practice, when a restriction requirement is issued by the examiner, you are required to file the divisional along with the response to the office action in which the restriction requirement was issued. But we had opportunity to also file them before the payment of the final fees. In the new law, it is specifically contemplated that all divisional applications filed due to the issuance of a restriction requirement must be filed either before or as late as the response to the office action is filed. You cannot file them later. Now, voluntary divisionals were being filed with the previous law, but they were not contemplated specifically in the law. Now, our new law specifically contemplates the possibility of filing voluntarily divisional applications, and it also contemplates specifically that the time frame for filing these divisionals is before the payment of the final fees of the parent case. Here in the slide, I put serial cascade divisionals at risk. This is because our new law contemplates a specific provision that says that you can voluntarily divide your application, but that you cannot voluntarily divide an application from another divisional. And if you do, the acceptance of this divisional would be submitted before the Patent Office. So previously, we filed several cascade or serial divisional applications, third, fourth generation divisionals without any issue. And now these divisionals would be at risk because they would be submitted before the Patent Office for their acceptance. And we do not know which criteria the Patent Office will have to accept or decline the filing of this cascade voluntary divisionals. But the good news is that the Mexican Patent Office will accept cascade divisionals in case the Patent Office requests the division through a restriction requirement or lack of unity objection. So that's in a nutshell the situation with divisional applications that we have in the new law. And with the Boller-Rocha exception, I'm just going to mention it very quickly because our colleagues in the litigation presentation also commented a lot on this aspect. But the only thing that is worth mentioning is that the Boller-Rocha exception was included in our health laws, but was not specifically included in the Mexican IP law. Now it is specifically included in the Mexican IP law, and so it does not limit to any specific timings, but it does mention that any third party can import products, patented products, in order to conduct the necessary tests in order to apply for a marketing authorization. So this is now contemplated in our law. Now, the patent term adjustment was also mentioned by our colleagues in the litigation presentation. In a nutshell, what we now have with this patent term adjustment is that applications that which prosecution lasted more than 5 years due to unreasonable delays attributable to the Patent Office will be able to enjoy a complementary certificate of protection. So how would this apply? Once the patent application issues, once we receive the notice of allowance, we will, before paying the final fees, apply the request for this complementary certificate, and the Mexican Patent Office will review if the delays were attributable to the Mexican Patent Office, or if the delays were reasonable delays, such as, for example, requesting extensions, or the period that passes from the filing of an application to the moment in which all formal requirements are met. So that is what the Mexican PTO will evaluate when giving or not this complementary certificate, which will last, for each 2 days of unreasonable delay, the Mexican PTO will grant 1 additional day of complementary extensions of the protection. So that would be all for my part, and Manuel will continue with patent protection.
Thank you, Mauricio. Well, under the provisions of the former IP law, it was possible to amend the patent, to amend the text or drawings of the patent to correct for formal mistakes or to limit and obvious mistakes and to limit the scope of protection. The new IP law also foresees this possibility, but it includes a broader proceeding and more detailed explanation on how the limitation of and correction of patents will work. Now, it will be possible to correct the information of the patent letter. This is, and it lists specifically the patent number, the classification of the patent, the name and address of the patentee, the inventor's name, the filing date, the priority date, the granting date, and the inventor's name, as well as the validity term established in the patent letter. It will also be possible to amend the claims of the patents only to correct obvious errors to a skilled person in the field, the technical field of the subject matter covered by the patent. The only case in which the amendments will not be accepted is if they seek to broaden the scope of protection of the patent, and therefore it will be possible to eliminate one or more claims in the amendment, or to include one or more dependent claims, narrowing the scope of protection of the patents. As for industrial designs, the amendment of the certificate will only be available if the characteristics conferring the novelty to the industrial designs are not eliminated. As a downside, it will not be possible to correct a patent letter if the patent is subject to an invalidity action. What we used to do in practice is, if we considered that correcting the patent letter would help to avoid the invalidation of the patent or one or more claims of the patent, then we filed a petition to correct the patent, to amend the claims, and ultimately we would file such resolution in the invalidation proceeding. Well, this will no longer be possible, but there should be other options available during the litigation to turn around this provision. Now, Daniel will be speaking about the invalidity actions.
Okay, well, as I was saying at the beginning of the presentation, it is important to determine when the application was filed to see which law will be applicable. All the new set of invalidity cause of action will be only applicable to patents that were filed after November the 5th and granted after that date. Any patent that was filed prior to that date, although granted after November 5th, cannot be invalidated under the new causes of invalidity actions. What has changed from one law to another? Well, the most important changes are two. In the former law, we had a generic invalidity cause of action that it could imply any provision of the law, and therefore an invalidity action could be filed under a violation of any provision whatsoever. That has been removed from the new law, and now we have a set of invalidity cause of action that cannot be broader. So it pretty much depends on when you stand. If you want to seek the invalidity of a patent that was filed after November 5th, you will only be available to use this new set of invalidity cause of actions. If you are dealing with a patent that was filed before, you can use the former invalidity cause of action, including this generic invalidity cause of action. From a patent owner point of view, it is clear that this new law provides more certainty about which are the defaults that can be finally involve the invalidity of your patent, and this uncertainty that was in the former law it is solved now. So if you're in the position of a patent holder or you're defending a patent holder, this new set of invalidity cause of action gives you more certainty, and it is a step forward for a better due process of law. The next one. Okay, question. Just two more remarks that are important. The first one is that the utility models are now changed in the new law, and they have a protection of 15 years instead of 10 that it was in the past. So that's an important change. It is quite straightforward. And the second one, it is not related to the new law, but it is also important for all of you to know that is that Mexico entered into the Hague Treaty, and this summer, it was in August, and therefore industrial designs can be applied and get the protections through this international treaty. And with that, Alejandro, give you the voice and
thank you.
Ask whatever question you want.
Thank you very much. Thank you, Manuel. Thank you, Mauricio. Thank you, Daniel. It was very, very clear, illustrative, and to the point of the topic today. So we have already some questions from the audience. So I'm going to read them, and any one of you can respond a question. I will start with this one. It says, how the company determine the remuneration, fair amount, for employee who created a possible new patent. The new IP law defines some rules. That is the question. Anyone?
No, the new law doesn't define any rules for this. I mean, what is important is what Manuel was saying, is that the labor contracts, domestic and foreign, are recognized, and that's the important thing. In terms of labor contracts for Mexican employees or foreign employees that are working in Mexican territory, what we have to do is to see what the labor law says. And in that respect, the labor law only says that the employee that is hired to improve technology or to develop technology is entitled to a fair compensation, having in mind the economic successful of the patent or the invention that is patent. What that means, there is nothing in the law to determine that, but it says that both the employee and the patron can fix a reasonable amount by a common agreement, and otherwise the courts will decide on that.
Okay, thanks, Daniel. Another question from Mary Ecker regarding e-sign assignments. Is there any requirement for a specific tool to be used? For example, DocuSign. Is there a witness requirement? Are there any other requirements that must be for acceptance of a digital signature?
Okay, so as long as the electronic signature is reliable, it will be accepted. It should be accepted by the Mexican Patent Office. What we usually recommend our clients is to use DocuSign or Adobe Sign, so that the examiner may verify that the document was indeed signed by the person that should be signed and the signature date. And the witness signatures are not a compulsory requirement for the assignments to be filed with the Patent Office, but it is advisable to give certainty to the documents. So there are no other requirements, and again, the filing of e-sign documents is a relatively new practice with the patent office. So there is not a formal criteria. All we have is what the law says, and there's not much about it in the law. So I think this answers the question, but if you want me to elaborate, please comment, Mary.
All right, Manuel, thank you. A new question from Isabel Claus. Can you confirm that the filing date is the PCT filing date? Does any Mexican application based on a PCT application filed on or after November the 5th is subject to the new law? So that is the question. I mean, if the filing date, it is regarding to the PCT filing date, in order to consider if the patent is going to be under the umbrella of the new law or the derogated IP law. That is the question.
Okay, so yes, the PCT filing dates for purposes of the prosecution of the national phase is considered as a filing date. So such patent application should be subject to the provisions of the former IP law. I don't know if Mauricio or Daniel have any additional comments on that or build on the question.
Well, I agree with Manuel. The legal filing date will be the PCT date, but if the application is physically filed or electronically filed before the patent office starting from November 5, it would be subject to the new law.
Okay.
Daniel, do you have any additional comments?
Yeah, I mean, the applicable law will be set by the day in which the national phase of any PCT application is filed in Mexico.
Okay. Further questions, I believe that these are going to be addressed to Manuel because part of his presentation is in connection with this. What are the requirements that need to be met in order for the examiner to admit an assignment or employment agreement?
So the most relevant requirement is that the document needs to be signed by both parties. When we file a document that it has the original signatures and has not been certified and legalized, we advise to file the document with both signatures. There are some cases in which the assignments or the employment agreements have been already filed with foreign patent office, and they only bear the signatures from the assignor as allowed by some of the foreign jurisdictions. In those cases, we do request our clients to send us the certified and legalized copy in order of the assignments in order to be admitted by the patent office. Another requirement is to specify the subject matter of the agreement, which could be indicated with the patent application number of the Mexican filing, or with the priority application number, specifying that it also assigns the rights to file in any other foreign jurisdictions. And I think the requirements for electronic signature documents have been already addressed.
Okay, thank you. Thank you, Manuel. There is another general question that I believe in the past it was a debate about this issue. The question is, are assignment documents needed for national phase PCT applications?
No. Well, the assignment documents are not requested by the examiner for PCT applications. Now, what the PCT regulations say is that if a declaration as of the entitlement to the invention was made in the PCT request, then the local offices will not require proof of the entitlement to the invention. In turn, if the declaration was not made, the patent office, the local patent offices, are entitled or are empowered to request the filing of any kind of documents. What really happens in practice is that these assignments are not requested by the patent office. If a declaration was made in the PCT request, they are not needed to be filed. If a declaration was not made or the assignment was not filed in the international phase, then we do recommend filing them, but it is not compulsory. And the assignments for all Paris Convention applications need to be filed with the patent office.
So why was the reason of this debate or some uncertainty if this requirement was mandatory or not? Do you know that?
Yes, the question whether it was mandatory or not is because the provisions of the PCT regulations are broadly phrased in some parts to that regard. It says if you make a declaration in the international phase, then such declaration is not so common for international applications. If you make a declaration, then you don't need to file, but it is broadly phrased regarding the situations in which you do not make that declaration. And it only says that the local offices may request the filing of the assignments. So whether or not in Mexico, that's the issue.
Yeah, let me just jump in, Manuel. I mean, the big debate was in litigation. It was not a big debate in prosecution. I mean, such declarations were accepted by our patent office without any problem, but, and you know this very well, Alejandro, we faced a lot of litigation contesting the lack of signed document, even though the declaration was made during international application. The good news is that, I mean, this is more clear. It was clear in the prosecution side, but it will be now more clear in the litigation, because the only provision or the only invalidity cause of action upon which the lack of submitting the assignment document can be contested is the cause of action that said that the patent was granted to a person that was not entitled to get the patent. That is, and in my mind, and now that the grace period provision has been broader to include a third-party disclosure in prejudice of the inventor or the assignee, it is clear that this cause of action is only for someone that was the inventor or the assignee, and which information was somehow stolen or inappropriate get from, and an application was filed. So in that respect, it seems that we have a more clear scenario.
Thank you. Thank you. Very clear. So now some questions in connection with patentability subject matter. Mauricio, are selection inventions available within the new IP law?
Hi, Alejandro. Well, the new IP law is silent about the possibility of having selection inventions. But what we do know is that in the practice, Mexican examiners accept them without any issue. We have had many patents granted for selection inventions in the past, and there is no provision in the new law to make us think otherwise. So, in my opinion, selection inventions will continue to be accepted in view of this new law.
Okay. Well, Mauricio, you mentioned that one of the main changes in the new law is the some rules for provisional applications and to sanction double patenting.
Mm-hmm.
So, which strategies would
Exactly.
you propose to avoid double patenting objections in view of the new IP law?
Well, the general recommendations that I would make are to think ahead when you file a divisional application. So I believe I didn't mention it when it was my turn to talk, but another provision that our new law has is that if when you divide, you exclude an invention or group of inventions from the parent case or the divisional, you cannot claim them again in the parent case or in the divisional. So let's say that the examiner issues a restriction requirement for 3 different inventions, and you keep invention 1 in the parent case, and you file a divisional for invention 2. Then invention 3, which was not included in the parent case and which was not included in the divisional, cannot be included neither in the parent nor in the divisional. So having in mind the limitations that we have for filing serial voluntary divisionals, and regarding the limitations that we also have in the groups of inventions that we file, the strategy would be to think ahead to when you receive a restriction requirement from the examiner, or when you receive a notice of allowance and you want to file a voluntary divisional, to think ahead on what matter would be of your commercial interest, maybe not exactly now, but maybe in the future, so that you can plan an adequate strategy for securing all of the matter you want to protect in the parent case and in the subsequent divisional or divisions.
Okay. Clear. New question. By the new law, the patent license is necessarily registered in the INPI office to protect the patent? I mean, if it's necessary or mandatory to record the license before the Mexican Patent Office, INPI, to protect the patent, that is the question.
So the provision of the new law says that the patentee or the licensee may register the license with the patent office. So it is not drafted, it is not worded as an obligation to the patentee or the licensee. They may choose not to do it, but recording the license have several practical benefits, such as if we're talking about pharmaceuticals, you should record the license in order to get the marketing authorization from COFEPRIS. That would be an example.
Okay, correct. Thank you, Manuel. So we have other questions here. You mentioned, Mauricio, about the possibility to file patent applications for new uses, and that the Mexican Patent Office accepts the Swiss type and the EPO 2000 formats. Which would you be the recommendation? Which form do you recommend best for practice, for practical, effects? What do you recommend in this regard?
Well, that is actually a very good question, Alejandro. Currently, the Mexican PTO accepts both formats, even in the same application. But if I would have to elect one instead of the other, I would recommend the EPC 2000 drafting, just because for the linkage publication purposes. Since the EPC 2000 drafting is drafted in a manner which is clearly directed to products, it would be easier to include in the linkage gazette than the EPC 2000 drafting, which could be interpreted as a process claim. So for linkage purposes, I would recommend the EPC 2000 drafting if you would have to choose between one of them.
Great. Thank you, Mauricio. So you also mentioned in the presentation about the possibility to request compensation of lateral patents based on the delays or justified delays during the prosecution by the Mexican Patent Office. What you can tell us, or what you can tell to the audience about this possibility, and also a recent decision by the Mexican Supreme Court applying some rules of NAFTA in the now already derogated IP law. So what would you be your comments, your practical comments in this regard?
Well, as Daniel and Manuel mentioned, first, before considering the request or not of this complementary certificate, we have to be sure which one would apply, because even though the application grants after November 5, if it was filed before November 5, then it would not benefit from this complementary certificate. So this would only apply for applications that were filed starting from November 5 onwards. So if we are in that situation, if we have a patent application that issues and that we believe, because of the time frame, that it would be subject to this complementary certificate, by the time we receive a notice of allowance, we would recommend to file a petition before the Mexican Patent Office requesting this complementary certificate issuance. And as I mentioned in the presentation, the Mexican Patent Office will evaluate if indeed there were at least 5 years of delay in prosecution that is imputable to the Mexican Patent Office. And from this 5 years, any period which, for example, if we request an extension, these extensions would be subtracted from these unreasonable delays, because they would be in fact reasonable delays. And also the period that would be subtracted from these 5 years is the period from which passes once the application is filed and once the formal requirements are met. So if you subtract all those reasonable delay periods and you still have a 5-year or more delay, then the Mexican PTO will grant an additional 1 day per each 2 days of unreasonable delays. So, that would be my comment.
Let me add something, Mauricio. So, I mean, long story short, the first complementary certificate that the Patent Office is going to issue is going to be in 5 years from now. So we don't, there's no legal possibility that any complementary certificate is going to be granted before that, just because of the timing that is set in the new law. But turning into this resolution, I think it's a well-worthy possibility to explore, although it has some, downsides, because NAFTA is not yet, it has been abrogated. Past law has been abrogated, but they could still apply for patents that are continue in prosecution or that were granted before any of those, either the treaty of the former law were abrogated. And this precedent can be explored for in other cases, and it could be a good way to get more patent protection.
Okay, perfect. We are running out of time, so if any of you can conclude with which of the topics that you mentioned is the one or are the ones that will have more impact in the practice of the patent prosecution in Mexico, as a conclusion, please do so.
Well, from the prosecution part, definitely the new disposition for divisional applications will have the most impact in our practice. So we invite all of you, all of our clients, all of our good friends, that if you're interested in filing a divisional, either voluntarily or due to a restriction requirement, to consult it with us so that we can elaborate the best plan possible so that you can obtain protection for all of the scope you are interested in. That would be my comment.
Okay. So, Manuel, Daniel, something else?
Manuel?
I agree that the most relevant change is divisional applications, but I think the patent adjustment term and the patent correction will also impact significantly correction regarding litigation and the extension term to seek broader protection for a longer time.
And from my part, I think the most important thing with this new law is to always determine which is the applicable law. And I foresee a lot of headaches and office actions not well grounded by the patent office because the new law is used on prosecutions in which the former law should still be applied. And for instance, in divisional objections from the divisional applications, we foresee a lot of headaches on that.
Okay. Well, thank you very much. With this, we end up with our day of ask to Olivares with this patent panel. Many thanks from our colleagues of Olivares for the 3 panels and for the efforts provided, but a special gratitude to the audience and to be part of this Olivares Day in celebration of the new IP law in Mexico. Thank you very much to everybody. Thank you. Goodbye. Bye-bye, everybody.
Bye.
Bye, thank you. Ya no hay atendís.
¿Ya no hay?
Ya no hay, ¿no? Tú lo puedes ver porque eres el host, ¿va? Manuel, estás en mute.
Yo veo a Alonso, a Eva, a Luz Elena, pero hay alguien más. José Guillermo.
Ya, Eva, ya podemos... ¿Ya nos sacaste la foto? Alex se fue. Hay que quitar la presentación, Manuelito.
Ah, ok. A ver. No. Sí.
Oye, ¿cómo nos fue en attendance, Manu?
Como 42 participantes.
Pero que... Deja de compartir.
Es que
En share, ¿no?
Está complicado. Es que en share no me da opción de hacer nada.
Yeah, it's at the top.
It's at the top in share?
At the bottom.
Yeah,
Oh.
just stop share.
It doesn't give me the possibility to click any of the options.
But you have file, edit, share, view, audio and video at the top. Click on share.
Sure, I can now do it. My screen.
So we deal every day with the state-of-the-art technology, and we suck at using it.
So okay, I think Liz stopped sharing because I couldn't do it.
I took it away from you.
Yeah, thank you, Liz.
It took the privileges.
Yeah.
Alex, ¿te salió?
Sí. So you took the picture, or?
Evangelina was going to take it. Let me see.
I think she's silenced. She's saying she's silenced.
Unmute her.
Okay.
Gracias. Es que si no, para que decirles a quién se la voy a tomar ahorita. Ahorita Si los demás cierran su micrófono para que esté Manuel en primer plano.
Ya tuvo mucho protagonismo, ¿no?
¿Ya? Ahí voy. Espérenme tantito porque la tengo que guardar. Ay, ahí voy. Espérenme tantito. Ya salió feo. A ver.
Sí, porque Daniel no está haciendo
Pues yo me estaba quedando en la vez, pues se ve la papada de Mauricio. Porque estaba así. Solo más se veía la papada.
A
ver, espérenme, ya tomé la de Manuel, así como está. Ok. Ahora, sale. El que sigue. Sí, Daniel, ahí estás perfecto. Ok, espérame.
¿Pero sí me ves?
Sí.
Sí, muy chiquito y nada más veo a Manuel.
No,
que
ahí
parece
estás bien.
fantasma.
Ahí estás bien. Ahora Mauricio va a tener que disculparse con los del panel anterior porque no les tomé foto. Porque me tuve que salir y ya no pude regresar.
Ok.
Listo.